And it looks like most everyone is in.
Well, good. I think that we will get going since this is the beginning of the panel. And in fact, we're just a tiny bit over time. So I'd like us to have enough time to get to this incredible wealth of global knowledge that we have on the panel. And so let me introduce the session. Welcome, everybody. This is the annual meeting of the American Society of Comparative Law, and it's our annual Hot Topics plenary panel, which this year is on COVID and legal trajectories across the globe, continuity or transformation. And I'm Francesca Bignami. I'm this year's chair of the annual program meeting, and one of the responsibilities of the program committee is to put together the plenary on hot topics. And we chose hot topic COVID because really now we've been living with the pandemic for 2 years almost. And so with 2 years almost under our belts, we really have a perfect moment here to take stock of some of the policy lessons and also reflect on the transformations that have been occurring across the globe in domestic and international jurisdictions, and that we can expect to be living with for decades to come. To tackle these issues, we have a stellar lineup of speakers on this panel, each with knowledge of a slightly different part of the world or a very different part of the world, as that might be, and also with this knowledge of a different dimension of the pandemic problem. And so this session is conceived as a world tour of sorts of the COVID phenomenon and the impact across the world. I'll be introducing the panelists in the order in which they'll be speaking, and so not in the order there, which is that you see on the slide here. That's alphabetical. My introduction is by order of speaking. So first we have Professor Jacques Delisle, who will be speaking on China, and he is the Stephen A. Kozin Professor of Law and Professor of Political Science at the University of Pennsylvania. He is also the director of the Center for Study of Contemporary China. He's a prolific author, and recently he has been publishing extensively on COVID and China and US-China relations in the area. Next, he will be followed by Jonathan Patz, who will be speaking on the public health policy of pandemics, both in China and globally. He is director of the Global Health Institute at the University of Wisconsin-Madison. He is also the Tony McMichael Professor and the John P. Holton Chair of Health and the Environment. Among his many, many scholarly and policy achievements, for 15 years, he served as the lead author of the UN's Intergovernmental Panel on Climate Change, the organization which shared the 2007 Nobel Prize with Al Gore. So from there, we turn to the WTO and Professor Patty Day Alai. She is Professor of Law at American University, Washington College of Law. She publishes extensively on international trade and comparative legal traditions, and in particular on the issues having to do with transparency and administrative law. Most recently, her work on US-China relations and their impact on the WTO have been receiving a lot of attention. Then we'll go domestic and back to, and we'll go to Italy with Professor Fernanda Nicola, who is Professor of Law at American University Washington College of Law, and she is the director of the program on international organizational law and development at AU. Her long and impressive research agenda has explored virtually every facet of EU law and EU-US relations, and most recently she has published on Italy's legal experience during the pandemic. And finally, we turn to Chile with the contribution of Professor Jorge Contese. He is Associate Professor of Law at Rutgers Law School, where he focuses on international human rights and comparative constitutional law. He has published extensively on human rights and constitutional law in Latin America. And Professor Contese has served on law faculties on multiple continents, this year visiting as a visiting professor at the University of Paris, Sorbonne Pantheon. So that's the lineup of speakers. We have an extraordinary agenda here, tour of the world, and just some logistics before we get going. Each speaker will have 15 minutes, and then we will have about 20 minutes for Q&A. Please use either the Zoom chat function, or if it's manageable, I'll also ask people to raise hands to pose your questions, and then I will try to bundle the questions and direct them as appropriate, because I do hope that this session can be as interactive as possible. And so now we turn to the substance, and we move to China and begin with China with Professor Delil. Thank you very much.
Well, thank you, Francesca, and thank you everyone for joining us today. It's a pleasure to be on this panel. I guess it's appropriate to start with China, since that's, after all, where COVID started. My remarks today are based in significant part on some stuff I've co-authored with Professor Shen Kui of Beida, so I want to give him credit for that. So we put an epigram at the top of those pieces that's a Chinese saying that roughly translates as the equivalent of success and failure come from the same cause. And I think the way to think of China's response to COVID, both the early failures and the subsequent successes by many measures, are reflections of features of the system, which are both for good and for ill in dealing with the type of challenge that COVID-19 posed. And for all the extraordinary nature of the challenge, it's kind of a microcosm of Chinese law and governance. So what you had is obviously a novel virus that challenged a system that had been reformed, a legal system, a set of regs and institutions that had been reformed in the wake of SARS, the previous similar disease, which was a good deal more deadly to the individuals who got it, but much less contagious and therefore wreaking much less damage. And basically what had happened after SARS was China revamped its laws for this kind of situation. It passed a much revised infectious disease law. It adopted an emergency response law. It adopted some public health emergency regulations and a direct reporting system for potential epidemics, and rejiggered a bunch of the institutions. Now, laws and regulations of this sort are, of course, only one part of how a place like China responds to these challenges. There's a lot else going on. Some of it's social, a lot of it is the party, and I'll touch upon that briefly. But basically, if you look into the early failures, and the failures were in some ways, much more short-lived than SARS. It didn't go on for months, but it went on for a crucial several weeks that proved to be quite fatal. At least by the fall of 19, there was evidence that this new disease was out there. Expert teams were dispatched to look into the situation in Wuhan in late 2019, the beginning of 2020. China notified the WHO on New Year's Eve that this pneumonia, atypical pneumonia, had surfaced. But it wasn't until late January 20th, and a couple of days that followed, that China publicly confirmed that the disease was communicable, and then the lockdown soon followed in Wuhan and then around the country. And then we saw the massive mobilization that counts as the successful phase, as it were, of the response to SARS. So the delay, although short, was fatal. And it reflects some of the characteristics of Chinese governance, which people who study Chinese politics generally talk about as the problem of tiao tiao and kuai kuai. Tiao is a long, thin stick. A kuai is a block of something. And what that really means is that if you are in charge of public health or a similar functional area in China at the subnational level, you have served two masters. You serve the geographic party state, principally the state, but obviously the party, at your geographic level, be it sub-provincial, provincial, and on up, but you also answer up a vertical bureaucratic chain to, in this case, the National Health Commission and the Centers, for some people, the Centers for Disease Control. And both of these approaches have some sense to them. The idea of the Tiao system, the up and down system, was to get experts involved, to get national attention to potentially nationally serious and indeed internationally serious problems, and to avoid the problems of concealment of difficulties at the local level, to avoid the fragmenting and balkanizing response that we saw in response to SARS, where local governments actually set up roadblocks to people getting in and out. The attraction of Kuai, the geographic focus, is, of course, it's the local folks with general competence who are going to have to coordinate across different parts of the bureaucracy to deal with the problem. They are ultimately in the Chinese system held primarily responsible, so make the power track the responsibility. So both have their logic, but when they coexist, it can be a bit of a problem. And I can't go into too much of the details here, but if you look into the reforms that were undertaken to the emergency response law and the infectious disease law and a bunch of other institutions and rules, in the wake of SARS, what you see is essentially a bunch of things which look very Kwai-focused and a bunch of things that look very Tiao-focused. So many of the responsibilities to identify, report upon, prepare for, release information about, mobilize resources to deal with these kinds of problems are partly attached to the local governments, partly attached to the public health regulatory system, and it's not quite clear who owns what responsibilities. In some cases, they're shared and overlapping. And so what you saw in the initial response was the pathologies of each of Kwai and Tiao and their coexistence. So on the Kwai side, there's a bit of an incentive to cover up. The local official, the mayor or the governor, faces something of a double or nothing bet when he faces a situation like an emerging disease. Do you follow the rules and report up? Do you let the Tiao system work so the local public health people can report up to the center? Or do you try to keep it quiet? If you report, there's a risk that you'll be deemed to have cried wolf if the crisis doesn't happen, that you'll be seen as attempting to shift the blame to higher levels, or that you will run the risk of looking like you're not fulfilling the two imperatives that all local officials in China face. First, social stability, which can be upset if you try to lock people down. And second, economic prosperity, which is also imperiled by a variety of public health measures. If you're wrong, however, you've lost the double or nothing bet. You've not only let the crisis fester, but you've violated your obligations up the chain. Many people take the first side of that bet, and that appears to be what happened in Wuhan. Whereas we all know they silenced Dr. Li Wenliang, who first tried to publicize the information that was about the diseases, the cases that were hitting his hospitals. The Wuhan Health Commission appears to have directed medical staff at the hospital level not to cooperate with delegations sent out from the center and from the province to look into the situation. There were 3 delegations. The third one finally made the report that triggered the lockdowns. And there was apparently, by most accounts, concern that if earlier measures had been taken, it would have disrupted the important political events of the municipal and provincial party congress and consultative committee meetings, and would have disrupted, with economic consequences and social panic, the Lunar New Year travel season, which just started when this hit. On the Tiao side, the problems are slightly different. They're problems really that feed into fragmented and ultimately ambiguous governance. So the extreme form of bureaucratic siloing that hits China is a real thing. The public health, so basically public health bureaucracy to deal with these things ultimately would have to collaborate with many other bureaucracies, as we will see happened when the response was successful. But in the initial moments, there was a bit of siloing. And the public health system, the Xitong, as it's called in Chinese, is weak. The Center for Disease Control is a mere bureau-level entity, a ting in the Chinese system. The Health Commission itself is headed by a minister, but it's a pretty low-ranking minister in the informal hierarchy of Chinese governance. The people who've headed it are not particularly powerful. And it was a relatively weak bureaucracy, not just because public health always gets subordinated to other things in most systems, but also because it had been through massive reshuffles. It had taken a lot of abuse, as it were, or at least criticism after SARS. And so there have been post-SARS efforts to beef it up, but there were still widespread complaints up and down the chain about how it was understaffed, underfunded, could only advise, had to cooperate and get permission at local levels, and basically didn't have enforcement or mandate issuing authority. And then there's the problem of these two things coexisting. When there's tension, Kwai tends to dominate Tiao. That is, loyalty is primarily to the local officials rather than up the chain. Local officials in Wuhan quashed the use of the direct reporting system. They interfered with the expert delegations sent from higher levels. Lots of complaints about what went on in that process. And so it's partly fragmentation, partly Kwai dominates Tiao, and partly the ambiguities of the legal regime. That is, that these authorities are not always consistent with one another, and the powers are distributed both to local governments and to the specialized bureaucracy. So one of the notorious incidents in the early response to SARS was the mayor of Wuhan, who, when asked why he didn't get the information out, he said, "I'm a local official, I need authorization to do that." And that was a plausible reading of the National Health Commission's mandate that says provincial level, but not sub-provincial level officials can issue information about a public health crisis, an epidemic or an emergency. On the other hand, the emergency response law says local officials are supposed to issue warnings about emergencies, whether they be public health or anything else. So there's some play in the joints there and an ability, at least retroactively, to try to justify a bad choice and to evade responsibility. Now, these problems exist everywhere. They're a bit more serious in China for a couple of reasons. One is that although there is a clear hierarchy of legal sources in Chinese thinking, the folk practice is rather different. Sometimes the more local level rule wins out because it's seen as more specific. Sometimes playing the bureaucratic politics puts you in that direction. And there's no meta rule. There's no sort of great way of resolving actual or perceived conflicts or to enforce conformity with higher laws rather than lower laws. There's no judicial review to do that in most cases. And there's the problem that this whole state and legal structure coexists with the party structure. And many officials are members of the party, so they're also subject to the party's dictates as party members and as people who understand the politics of governance in China. And so you get fairly early on in the pandemic, no less an authority than Xi Jinping saying everybody in the party should be out there taking aggressive measures to deal with this. Well, what? And how does that interact with the law? And there's a pre-existing Xi era regulation that basically said if you have a problem, a complicated problem, request instruction and reports from higher levels of the party. So it in a sense adds a third non-legal, non-formal layer to the complex environment in which officials responsible for dealing with these problems have to operate. That's the bad news story. I'll do the good news story in shorter order because I know I'm running through some time here. And that is the systemic strengths then kicked in. What China was very good at is mobilizing. So when the system, those at the top of the system decide it's time to centralize and coordinate, they can do it pretty well. And that's what happened in late January of 2020. Now here, law did play a role, or at least have a framing function. The emergency response regime was triggered to call this a level 1 crisis, which triggers a bunch of controls and authority. The new, not yet called SARS, not yet called COVID-19 disease was classified as a Class A pathogen, and that triggers a bunch of authority, a bunch of controls. The lockdown procedures had some basis in the regulations, and there was just massive coordination across sectors. So public health, transportation ministries, even the army, and the state council set forth a so-called joint prevention and control mechanism to coordinate across 32 different sectors of the bureaucracy. So there is this ability with some legal underpinning to coordinate the response. And we saw the surveillance state in China, which also has something of a legal underpinning, kick into gear. Artificial intelligence, the ubiquitous cameras, facial recognition technology, QR codes to control access to anything. You had to get your green pass, and they did that way before certainly my university started doing it. But it happened really quickly in China, and the system was in place to do that. That coexisted with some old low-tech methods, which reflect the extraordinary penetration of the Chinese state and party state down to very local levels. And one of the other innovations of the Xi era had been to establish a so-called grid system, which put cadres, agents of the party state down at a much lower level into the system. So when an order came down from on high, be it a state order or a party order, it was much more thick on the ground in terms of the ability to implement it. And Xi Jinping and the State Council, emphasized the need to use law and rule of law to cope with the crisis. And so we saw, a lot of rhetoric in that direction. There's another legal dimension here, which is something that distinguishes China from other countries. Some of what I said does too. But this one is that there was almost no real legal check on the state's authority to do this. Nobody worries about constitutional or legal authorization for these measures. There's no separation of powers issue. There's no judicial review to challenge orders as excessive. No local authorities will claim federalism-like power, individual liberties and rights, and the ability to seek judicial review. None of that was going to get in the way. People criticized overreaching. For instance, some of the surveillance and tracking mechanisms were on the basis of normative documents that didn't lack the status of law. But that's a nice point, but it wasn't going to go very far in that system. So that's kind of where that was sort of what enabled the strong response. And in my last couple of minutes here, I want to turn to what's likely lies ahead. So one of the things coming out of SARS were all the reforms that were supposed to help with COVID, and I think in some respect did, but fell a bit short. So we've seen calls for another wave of legal reforms post-COVID. Xi Jinping and the State Council, China's highest executive body, said law matters. We got to turn to law to fix this. We've got to amend the laws to make sure this doesn't happen again. So we're seeing some things that look like a redux of the SARS reforms, once again trying to clean up, strengthen, sort out the lines of authority in the emergency response law, the infectious disease law, and other such things. We've seen tougher criminal penalties for the spread of pathogens. And we've seen a restructuring of the bureaucracy for disease control with a more proactive prevention body under the NHC. We saw in the middle of the crisis the issuing of all these shutdown orders for wildlife trade and wild animal behavior. And now those are being put into amendments to the wild animal conservation law, the animal epidemic prevention law, and a new biosecurity law, which would address, among other things, labs. So if you like the lab leak theory, there's something in that for you too. But I'm going to close with a bit of pessimism on how these reforms are likely to go. In some ways, it is SARS all over again, and those reforms didn't solve it. And the Tiao Kwai problem is still built into the new set of reforms. They push authority in both directions. Some of the laws that have been adopted or are on the books, are on the boards, are ones that are going to be hard to enforce. It's a Chinese saying that implementation is difficult, and every bureaucrat will tell you that. And the implementation of something like shutting down wild animal markets is particularly tough. They're hugely numerous, they're all over the place, local folks like them. And if you're trying to shut down sensitive labs or regulate them, well, that's got its whole sort of security protection where the public health folks aren't going to get to do much work. And then we've still got the issue of the coexistence of the party, which is, if anything, growing more robust under Xi. So the tensions and ambiguities between party rule and state law are a bit more fraught than they used to be. And I think there remains a lack of appetite for the kind of reforms, more liberal reforms, that might help with addressing some of the cover-up and poor information that we saw in the initial response to COVID. There's talk of the right to know, the right to information, much criticism of the silencing of the whistleblower Li Wenliang, but you're not going to see radical changes on that front. Media is, if anything, even more controlled than it used to be, so too social media. And the internet and the reaction to the international criticism and the call for cooperation with the WHO doesn't exactly look like we're headed toward great transparency. All the measures, the administrative litigation law has been expanded slightly, and it would allow ordinary citizens to help whistleblow, as it were, through legal means, misbehavior by local officials. And again, there's been some modest expansion there, but I don't think we're going to see a whole lot under the current circumstances. And I think the takeaway from this is that, unlike in many other countries, China's response to the exceptional challenges of COVID were kind of consistent with the way the system operates and is almost designed to operate. And in retrospect, after the initial crisis, there's a sense it worked pretty well. And to the extent it didn't, the regime is not in a mood to hear criticism from its own citizens or from abroad to push it toward more fundamental reform. Thanks.
Thank you. Professor Pats, please.
Yeah, thank you very much. It's a pleasure to be here. I will tell you, I am not a lawyer. I'm an environmental health scientist. So I'm going to be giving you some provocative slides. And because I'm not a lawyer, maybe I feel like I have some latitude to do that. So can you see the first slide okay? Right, good. Okay, thanks. So I'd like to challenge you to think about expanding the legal landscape in the wake of the pandemic. And I'm going to give you some examples of why I think we need to look more broadly. Start right away with some ecology, and I'm sure you've all heard about zoonotic disease spillover, and that coronaviruses, the reservoir hosts are in bats. And it's very likely, from what we know about Hendra virus, a similar virus, bat-borne viruses, and other coronaviruses, is extremely likely, and a brand new study just came out last week, that this came from nature, from disrupting nature. And as you see here in this diagram of all these tiles that are lined up, that only when they line up, which is rare, do you get a spillover event from a virus in wildlife into humans. And land use change and habitat disruption and climate change actually are some of the drivers of this first domino falling that can lead to a spillover event as occurred in the COVID-19 pandemic. So when you see something like this and you recognize how important it is as far as disease prevention to include environmental factors, do we need to expand the legal framework? And when we see, forest conservation under threat, this is looking at in the Amazon, when Bolsonaro came in, rapid increase in deforestation, and we know about links between deforestation and disease emergence. There right now, this week, calls for Bolsonaro to be liable for all the deaths in Brazil for not acting earlier and for just wanting just laissez-faire, herd immunity, and forget intervention. So they're calling him out on this. But what about this other issue? Is there any legal framework about once we establish links between land use policies and conservation, should this be under a legal framework if we can connect the dots to some of the first factors that cause a pandemic? And I'll just show one study that also suggests that climate change impacts in the region in Southeast Asia, which led to a shift in bat migration, could be one of the other factors that led to this. So I challenge the legal experts to think about, getting to the root causes. Are there legal instruments to include this in the scope of things so that we can be as upstream and preventative as possible? Now I'm going to show this. This is probably what you expected me to talk about. So I do want to show one slide to show how the COVID-19 pandemic has laid bare the incredible health inequities in our country. When you look at the Black population, almost 4 times more likely to die from COVID-19 compared to the white population, indigenous population way up there as well. So absolutely, this is something that is just, it's unconscionable how unfair our health system is in this country, and who's at risk of dying. Certainly we're talking about underlying conditions in many cases, but why do we have such underlying conditions? And it's just so revealing about our healthcare system and the inequities. So I would expect lots of legal issues here, but I want to go a little bit further because I am an environmental health scientist, and remind you of this picture that I'm sure most of you saw in various forms of op-eds, the before and after picture when COVID struck and we shuttered the global economy, which is a fossil fuel-based economy. What could be any clearer comparing today's air quality compared to business as usual, in the middle of the pandemic? Well, yes, air pollution kills a lot of people, up to 9 million premature deaths every year. But there's a COVID story here. If you compare the deaths from COVID in the United States, that's on the bottom, compared to the top map, which is fine particle pollution, PM 2.5, there's a correlation. And this study out of Harvard University found that just for a tiny increase in PM 2.5, 1 microgram per cubic meter, an 8% increased risk of dying from COVID. And around the world, if you look at deaths from COVID and the air pollution in those regions, we're talking about a significant from fossil fuel combustion. In East Asia, maybe 15% of deaths from COVID were exacerbated by air pollution. So yeah, I get choked up when I talk about air pollution. I'll take one more sip. But these are things that people are not thinking about with this pandemic, that there are multiple factors, and that environmental quality is a risk factor for dying. This should be put on the table if we're thinking about, what needs to be done to be proactive and to avoid suffering and dying from COVID. We need to think about air pollution. And, when we did shut down the fossil fuel economy, at this time, do we really want to uncork their current fossil fuel economy or build back better and get a clean energy economy where everyone prospers? Again, I'm not a lawyer, but I want to ask this question, that if we're not waiting for technology, if we know the answer, and that if the cheapest way to generate electricity right now, for the first time ever, is renewables and batteries, if you remove all subsidies, is there legal precedence to say, we need to, for public health reasons, we need to shift our energy? And I'll just wrap up with some recent findings from the Lancet Countdown, which was just released yesterday, which is an activity that looks at climate change policies related to health. If you just look at three big sectors, energy, the food system, and urban planning and transportation, low carbon scenarios that are in par with the Paris Agreement will give us huge benefits. And this is a study that looked at 9 countries that are emitting a large majority of fossil fuel emissions. And if we were to get to the Paris Agreement, millions of lives saved from cleaner air, healthier food systems, and cities designed for people rather than for single private vehicles. So huge savings. And in the United States, if we were to really get to carbon reductions by half, we're talking about 1 million American lives saved every year. And so I end by just asking this question: when we see how fast we've mobilized trillions of dollars to fight the pandemic, why don't we treat climate change like an infectious disease? Because after all, climate change is a global health crisis. And I'll end with a cartoon that you've probably seen before, that COVID-19 is a big problem, but there's another huge problem right behind it. So I hope that I've given you something you weren't expecting, but has some relevance to expanding legal framework as we have lessons learned from COVID. Another lesson learned is our response to the COVID pandemic, knowing full well that it was coming and being so slow to respond, and the parallel situation right now with climate change. So that I hope the lawyers of the world can help us solve this problem, both of these problems. Thank you.
Thank you very much for that incredibly holistic perspective on the problem. And so now we go to the world trading system with Professor Alai.
Thank you, Francesca. Thank you for inviting me to join this amazing panel. But right now, after Jonathan's presentation, I just want to talk about what he just said. So I'm going to change my, hopefully I'll be short, there'll be enough time to have a discussion. I'm going to talk about the World Trade Organization's role with COVID, and specifically why I view what it happens regarding COVID is important for the WTO as an institution. So I'm going to talk more about the institution vis-a-vis the COVID pandemic, but I come at it from an institutional angle. That's what I wanted to mention. The WTO just appointed recently a new Director General, Ngozi Okonjo-Iweala. who was formerly the chair of Gavi, the Vaccine Alliance, and also she was recently appointed by the African Union as special envoy to mobilize international financial support for fight against COVID, and also the WHO special envoy for access to COVID-19 tool accelerator, which was launched in 2020. Her profile and the fact that she's the first woman and the first African to be the Director General of the WTO is significant in itself. It's also significant because it comes at a time when the institution is in a transition and really in search of, I apologize, an identity in a way. Reform has been asked for, and it is wobbly, let's say, at this point in time. For somebody who's a fan of a rule-based system, I believe it is a unique institution that looks for and protects rulemaking and on a global scale, which we need. I think it has a particularly important role to play. So I go a little bit backward to say, why are we where we are right now? Those of you who may be familiar, I apologize if this may be repetitive. As though most of you know, the WTO replaced the GATT in January 1995, 50 years after it was supposed to come into existence as the International Trade Organization, being the third arm of the Bretton Woods institution. Unlike the other two, the International Monetary Fund and the World Bank, it's not power-oriented, it's consensus-based, in a sense that voting is not based on how much money you put in the institutions that it is in the IMF, but it's based on technically one country, one vote. But of course, the size of the market matters in trade. So we've tried to, it has been consensus-based, try not to get to voting, because the fear is that we don't want to look like a UN General Assembly at any point in time. So what has been the role of this system? Two goals have always been out there. One was market access, meaning liberalization of markets, removal of tariffs, quotas, and non-tariff barriers, which include anything under the sun, including any kind of domestic regulation like health and safety regulations, food safety regulations, product safety regulations, etc. The second goal has always been non-discrimination, which means that you should not discriminate against countries that you trade with, or you should not protect your own and discriminate against imports vis-a-vis domestic products. There was always a third goal, which was not very clear. Contrary to what it was said, the transparency goal was kind of opaque. It wasn't clear what that goal is, except that it was important that trade regulations get published. The United States promoted that language and inserted it because we had just passed the Administrative Procedures Act in the United States, and we wanted something similar on the multilateral front. With the creation of the WTO 50 years later, we had seen the rise of a regulatory and administrative states. We added trade in services as well as intellectual property rights to its mandate. So we are talking about no longer removing regulations in terms of having our free market ideals, but what is an appropriate or WTO consistent regulation and what is not, looking for regulatory convergence possibly or harmonization. Then with the creation of WTO, a fourth goal was added, which may or may not have been a goal, but it was added to the preamble, which said that the goals of the system should be consistent with the objective of sustainable development, and also the goal of preserving the environment, right? So this language is in the preamble. What does it mean? Does it mean that the WTO, the trading system, must balance market liberalization, non-discrimination goals with this concept of sustainable development? It's said its primary reason for being is to remove trade barriers. What about these other values? And that has been going on for the last 25 years. And increasingly so, it's become clear that it cannot disentangle itself. It no longer is the time of the GATT where it can only divide the world into economic and non-economic issues. So it became a challenge to its legitimacy, and we all know the protests that were against it as being anti-rights, anti-environmental, the sea turtles, against sea turtles and other species. There's been issues with regards to whether the subsidies rules can cause problems in regards to climate change, etc. Of course, there has been a greening going on, but it's still not clear how the balancing works out. At the same time as this was happening, of course, the negotiations completely have stopped. The rise of the BRICS, India leading then sort of the opposition to further liberalization in the IP sector and services, while the Europeans and the Americans continue to subsidize their agricultural sector and the textile sector. So we have had an impasse, but the WTO created a wonderful dispute settlement mechanism, in my mind, that was unique and is unique in the history of international law, mainly because it's a standing appellate body, which ceased to exist in December 2019, was the only international sort of organ, international dispute settlement organ that had an enforcement mechanism. Its enforcement mechanism meant that it could allow one country to impose retaliation, or what we call suspension of concessions, against another. For many reasons that I can't go into because that's not the focus of my remarks today, or there's no time, the United States opposed the appellate body because they didn't like some of the decisions that came down, specifically in the areas of trade remedies. But it's a bigger issue, I think, because it sort of was the world ready for a tribunal, a global sort of supranational regulatory body in a way that the WTO was evolving. Can something stand above nation states and review administrative decisions of domestic states that have been okayed or have not been addressed on a domestic level in terms of their consistency to WTO rules? So by 2019, we basically have lost the appellate body and have a weakened system of dispute settlement. Now, the reason for this weekend is, some of it is because we had very enthusiastic, maybe some argue we have had some very enthusiastic public international lawyers who did not understand that trade is about diplomacy, and you cannot see this as a domestic or international court, but it was really a dispute settlement mechanism that was subject to politics. And they didn't take that into account when they came down with their decisions, where the United States was warning, and this is a bipartisan issue, from the Obama administration to Trump administration to the Biden administration, that they did not agree with the ways that the appellate body was interpreting US law and its compliance with international agreements. But another big issue is something that has been discussed, was China. China's accession to the WTO in 2001 was seen by both the United States and the European Union as a positive movement. The hope was that with its additional obligations, including in its protocol of accessions, that it was now going to sort of moderate, become more transparent, and hopefully help towards incorporating into the system instead of operating it outside of the system. The United States may be regretting that. I can't speak for the administration, but in 2007, China did a lot of things that I think maybe the government wanted to do, but they now had the WTO obligations as a reason to do them. They adopted an open government information regulation. I don't want to talk in front of Jacques about what the Chinese have done, but they published 72 million records. They had 30.8 million requests. This is back a few years back when I checked. They set up an inquiry and notice and certification point in MOFCOM. But it sort of became clear that we cannot control and change China and through the WTO, and especially through its dispute settlement. I think there was a feeling that the dispute settlement maybe in actual cases can hold China accountable. The fact is that we knew the system back even in the 1990s, even before under the GATT, we could not address systematic things like we had problems with Japan in the 1990s, cannot be addressed when you have a model of a sort of a market economy model, and then you bring something else within it, you can't expect the behavior to sort of change. And for the dispute settlement body or for the WTO to be able to change how an economy is organized. It also, I think, was important to realize that our understanding of legal transparency, it doesn't necessarily translate in the same way in the Chinese mindset. Again, I'm not a Chinese expert, so I'm not going to say that, but to the extent that there's a history of rule by law as opposed to rule of law in China, it didn't translate in the same way. President Xi is quoted as saying, and this I think is very reflective, when those who uphold the law are strong, the state is strong. When they are weak, the state is weak. So it's less about the law itself, but how you wield it and how much power you have. It was the hope of the United States that the China's accession would, and the acquisition of additional transparencies would push China towards a more open economy and society. So where does that leave us, and where does that leave us with COVID? So WTO is in this difficult position. There's China in there; it hasn't been able to do it. The United States is lukewarm. Its dispute settlement system is put aside, and then we are hit with the COVID pandemic. And I believe that there are certain things in the WTO that really were not talked about very much, but were very, very useful in this pandemic. And then there's much more that needs to be done. In November, when they have their ministerial, the question is there going to be an agreement on what they can do with regards to both patent waivers and compulsory licensing, as well as other issues like fisheries subsidies and things that are more and development. So the WTO had in its place several monitoring and notification systems. It has an agreement on technical barriers to trade. It has an agreement on sanitary and phytosanitary measures, which are really health measures. It has agreement on intellectual property rights. It has a trade facilitation agreement, which deals with border measures, and it has got government procurement agreement and an agreement on agriculture. So all of these were kind of useful. The notification requirements that are contained in these are important for maintaining transparency in a pandemic. The record-keeping nature of the notification and monitoring systems provides WTO members with a repository of information to reference during crucial decision-making. The transparency obligations under the WTO agreements enabled the WTO to gather information rather quickly that related to COVID-19. From mid-October 2019 to mid-May 2020, 363 new trade and trade-related measures were notified in the system, and 198 of them were trade facilitating, and 168 were trade restrictive. But 250 of all of those were COVID-related. In May 2020, the General Council meeting of the WTO urged the members to exercise maximum restraint in the use of export restrictions and other measures that could disrupt supply chains. And there was a call on members to improve transparency on new COVID-19 caused trade-related measures. 65 WTO members agreed to maintain information and view sharing on COVID-19 trade-related measures. By October 2020, 39% of the restrictive measures in trade in goods that had been adopted immediately at the start of the pandemic were removed, while the rest still remained, particularly in the heavily impacted services sector. There is constant monitoring and notification still going on. The WTO led to the establishment of the COVID-19 Trade Facilitation Repository, a joint platform created by UNCTAD, WTO, WHO, and the World Customs Association. I also, the WTO has had a compulsory licensing provisions in Article 31 of I know I'm running out of time, so I'm going to very quickly wind down. Article 30 of TRIPS that allows for compulsory licensing in cases of national emergency and other circumstances of extreme extreme emergency. In October 2020, government of India and South Africa, with support of 62 other countries, put a proposal for temporary waiver of intellectual property protection on COVID-19. They modified it in May 2021. The Biden administration is sort of supportive of it in a narrow way. They have been supported by the Asian Pacific Economic Cooperation. The EU has submitted an alternative proposal for equitable access and compulsory licensing use under TRIPS, reducing of export restrictions and keeping supply chains open. In addition, there's a pharmaceutical agreement under the WTO that was negotiated in 1994 that can be expanded to include PPEs and other things that are related to COVID, in addition to pharmaceuticals. I believe that that pharmaceutical agreement is also a unique place where if there's an agreement, it can not only be useful for this pandemic, but it can be useful for other pandemic going forward. The question is there going to be a will, and will the WTO sort of come back and find its mission here with issues such as this pandemic? So I'm going to stop there. I know there's much more I want to say, but I think I'm out of time. Thank you.
Thank you very much. And now to Professor Nicola and Italy. Thank you.
Thank you so much, Francesca, for organizing this great panel, and I'm thrilled to be in this venue, even if online. I really wish we could have met in person, since I always get a kick from our meetings and love to be with my colleagues from whom I've learned a lot. So what I'm going to talk about, and I'll be in the timing, I'll start my timer. I want to talk about what happened with COVID-19 and why I decided to do a very narrow study on Italy, which though after this presentation, I realized how much my study on Italy that is influenced by the comparative law tradition is actually a deeper study on functional equivalence with issues of conflicting competences or overlapping competences between state and regionalism, but also vis-a-vis states and international regimes with Italy and the European Union. And finally, a deeper question, and I'll share my screen now, which is the, I hope you can all see the slide. Can you see it?
Right. Yes. Yes, it looks good now.
Yeah.
Great. I got it. Okay. Which is the deeper question, which is what happened to Italy was really a moment of populism, and Italy didn't slide into authoritarianism as it happened for other countries. So let me just go to the previous slide, if I can. Oh, it already went to the second. I don't know how to go back to the first, but anyhow. So the issue, sorry, can I go back to the first slide? I cannot control this thing for some reason.
I believe you're up, down, or
maybe you're controlling it. Oh, thank you. Great. Okay, so let me say that in April 2020, with Nezum Abubi and Kerry Corjanese, they organized for the regulatory review this symposium issue. And that's how I decided to write about, is there even what we could call in comparative law an Italian model to fight COVID-19? And at the time, Italy was very much hit by the pandemic. It's the biggest European nation that had direct contact with Wuhan. Here you can see the Dome of Milan, completely empty. In Milan, the first cases of COVID-19 happened, and the Lombardy region was in a deep lockdown with a number of cases, huge amount of deaths, and really by March, the country was in this terrible lockdown. If I can go to the next slide. Okay, here. So by the time after the blog, I decided to write an article with Professor Scaccia, an Italian constitutionalist, and we came out with this with this great volume organized by Kerry Kogianese and Nathan Maibabi for the administrative law review. So I think it was a terrific way to bring our comparative insights in a national administrative law journal that was now interested in how other countries effectively used and other regimes used administrative law to fight COVID-19. If you can go to the next slide. What's interesting that many of the contributors, as you can see of the volume, are also in this panel. So that's terrific that we find each other here. And there was basically this idea that there were some functional equivalents and some ideas of regionalism or how to address the pandemics in terms of we have strong central government, stronger executives, or are we seeing that this crisis is undermining or fostering executive authority, and other questions of the sort. In our article with Professor Scaccia, we basically showed how the kinds of conflict that also Jacques addressed in Italy were very much regional conflicts, where certain regions were really at odds with the kind of initiatives, especially the tough lockdown measures that at the time the Prime Minister Conte had undertook to address what was an unknown pandemic in terms of we didn't know the extent, and also how to really make sure that the population wouldn't travel, wouldn't get contaminated. So what happened, what we basically recommended in this article was really to promote a regional differentiation and really show how not only the pandemic had affected regionally very differently. Certain regions needed the lockdowns, others didn't. The lockdown was implemented as a very top-down measure. There were examples of regional collaboration, especially with public health authorities. Health law is a joint competence of the national government and the regions. Therefore, there was lots of problems in terms of who's in full control of the regional hospitals. How do we create new regional hospitals? And what you have to know that at the time, the Conte government was also a kind of a unique government in Europe, because it was the result of an election in which two populist parties had won the elections, a center-right populist party, which is still a nativist, conservative, anti-immigration and racist party led by the Northern League, and a more progressive, anti-elitist, very mediatic and anti-kind of established media five-star so-called movement, and not even party. So both parties at this time are in the government, and Prime Minister Conte, who's a law professor, a private law professor in Florence, took the leadership of the first government, and then even he got a mandate for a second government in late 2020, where he basically enforced some of the measures that we talked about in our article. So what happens in Italy in 2021? And this is very interesting, and I think it's very telling in terms of, on the one hand, we have a new government, this time created by the president himself, when it's clear that money is going to come from the European Union under the Next Generation Fund, the Next Generation EU, and the way that Italy can show its willingness to receive this money is only through reform. And the populist parties, together with the center-left party, all ally and and there is a big coalition that stands behind Prime Minister Mario Draghi. As you know, Prime Minister Draghi was also in charge of the European Central Bank for over almost 9 years. He was in Frankfurt, and he did whatever it took to save the euro during the financial crisis of 2008. So having a strong figure that was legitimated by the European powers, of course, Draghi could pick up the phone and call Angela Merkel or President Macron of France, was a certainty to attract this money and created a big coalition. In the Draghi cabinet, we have also two interesting people. Minister Brunetta, who was supposed to bring deep reforms of the public bureaucracy of Italy. That is something that the European Commission had asked under his austerity plans for a long time. But also Professor Marta Cartabia, who was one of our guests when we hosted the American Society of Comparative Law annual meeting. She's a comparative constitutional lawyer, first woman president of the Italian Constitutional Court, who's now the Ministry of Justice. So we have this prominent cabinet. The Mario Draghi cabinet is attracting the European funding, and we still see cases of rebellious regions that still are in conflict for various reasons, including, for instance, northern regions that want to open their ski resorts, and the Italian government doesn't want them. And so there are litigations. These litigations go in front to the Italian Constitutional Court, and here you can see really the legal structure where the Constitutional Court is the ultimate branch resolving these disputes of region states, and the Constitutional Court comes up in early 2021 with a ruling in which it says, because of this global pandemic, we reinterpret the article of the Constitution that that discusses the share and overlapping responsibility in public health between the regions and the national government, and in a time of an international emergency, the national government has taken over the competence of the regions and has the ultimate word in deciding the issue. So the decision of the Italian Constitutional Court settles the matter of the rebellious regions. And what's interesting is that we get to the government Draghi taking two incredibly strong measures, which have been partly the subject of protest. One is the centralization of the vaccine campaign, very successful. Today, we are almost at 80% of the Italian population vaccinated with the deployment of the army. And I'm not joking, there were army and the Alpine troops in the squares. But the other big thing was the Italian Green Pass. There's been a subject of lots of discussion. It's not a mandatory vaccination, but it's a Green Pass that it's required to go into indoor dinings, museums, gyms, theater, other social activities, and especially to work. As you've seen, there's been strikes in the harbor of Trieste over this issue. The number of workers in the harbor of Trieste is pretty limited, but what's interesting is that this is becoming a flagship for the disgruntled people with the Green Pass. If you need this Green Pass, you can have it either through a vaccination or you can get tested every 2 days. And as you know, in many European countries, but also in Asian countries, testing is subsidized by the state. So with 20 euros, if you decide not to get your vaccine, every 2 days, you should just get your testing. And that you can comply with the Green Pass requirements. Okay, on the other hand, the stimulus money is coming in. So despite the protest, the civic protest, you also have lots of checks coming into the pockets of people, going to businesses, workers, and for health expenses. So there is a kind of social appeasement at the same time that there is limited social unrest. Here's the last point I want to make that really comes from where we are right now, which is the American Society of Comparative Law. And I want to bring three books that came out in the past few years, which are really relevant for our discussion. And one is Francesca's edited volume on EU law in populist times. But the questions here is really why there hasn't been an Italian slippage towards authoritarianism when two big populist parties have been active in the Italian government in the past 3 years, and they've had lots of kind of the features of the populist regimes. And I think Gunther Frankenberg's recent book, they uses 4 markers for how do we do the slippage from a populist regime to an authoritarian government. Can be used to show how Italy really didn't have the executive slippage, but there was at a certain point when the president nominated Prime Minister Draghi, also made sure that the executive legislation that was adopted by the Conte government as a very strong executive style was somehow limited, and the parliament was brought in to continue its democratic role. There's many other features of authoritarianism that really do not fit the Italian experience. So if Italy didn't slip from a populist regime to the authoritarian model, as the European Union played a role in all this. And we know from Francesca's book that some of the markers of authoritarian strand of populism have led to the clashing of EU law with the European Constitutional Justice, Court of Justice. We see today with Poland, that's the most obvious example where we have a direct clash between the rule of law as imagined by the European Union and the rule of law as considered by the Polish, wanting to have complete control of their judiciary, especially the Law and Justice Party. Italy didn't get to that type of clash, but neither to the other kind of clash over economic or migration issues, which drove kind of the anti-elitist and populist base. That didn't really happen in Italy, even though the Northern League would have more of this tendency, because part of the populist movement is more, it's more driven by certainly an anti-elitist, but also the five-star, more progressive movement, which wants a state that is more transparent, but still very much involved in what the Italian population needs. So support for children, schools, welfare, that's very much the case. So I've used Professor Tashnet and Professor Bugarich's work, and in their ideal, how do we reconcile populism with constitutionalism? They certainly look at the varieties of populism, and certainly look at the way the five-star movement has allied itself with a more traditional vision of liberal constitutionalism. And finally, back to the regional government, the Italian very divided geography also showed recently in the recent elections how the cities like Milan, Turin, Rome, Naples, and Bologna, in these cities, the center-left party took over again and became the major leading party, as opposed to the five-star or the Northern League movement, showing that just like before Mussolini, Mussolini was elected in 1924, and in 1921, there was a municipal election that allowed Mussolini to take power. And so this is a good marker for Italy not slipping towards authoritarianism. Thank you.
Great, thank you so much for that comprehensive overview of what's been happening over the past 2 years almost in Italy. So last, we have Professor Contese on Chile. Thank you.
Thank you, Francesca. Thank you, everyone, for being here. I will be talking about the case of Chile, but before doing that, I would like to situate in the more general context of the Latin American region. And so just to share some figures to get an idea of how COVID affected the region, the Office of the High Commissioner of Human Rights in April of this year made a statement presentation sharing some information on how the pandemic has affected particularly Latin American countries. And so just to share with you some of these figures, by December of 2020, the pandemic had affected 8.4% of the world population. And despite, Latin American region being 8.4% of the world population, the amount of people who had been affected, meaning active cases, amounted to 18.4%. And more significantly, the Latin American region amounts to 27.8% of total death in the context of COVID-19. So this gives you an idea of how the region has been largely affected, and some of the structural trends of inequality that are pervasive among Latin American countries made its way in the context of this pandemic. So the same report, it's not really a report, it was really a statement by Michelle Bachelet, and in which she was reflecting on how Latin American countries, even though they reacted pretty quickly, they responded to the WHO declaration of a public health emergency of international concern, first at the end of December of 2019, then at the end of January of 2020, and then by March, when it was declared as an actual pandemic. There were interesting responses, right? Legal responses. And for a conference that is reflecting about internalization of comparative law, this is, I think, particularly interesting because you can see a sort of the legal mechanisms being triggered by an international declaration. So the domestic response of different countries in conjunction with this international declaration, this international statement by the World Health Organization. Now, the Office of the High Commissioner of Human Rights stated very clearly that there were concerns about how Latin American countries had, these are my words, used, this is not something that any United Nations, I think, organ would say in a context of diplomatic relations, but how they used the pandemic to implement very strong measures restricting civil liberties and fundamental rights. The Office of the High Commissioner talked about how there were significant restrictions to, quote, civic space, right? So freedom of association, freedom of movement, of course, freedom of expression. And all of this was happening against, again, the backdrop of this structural inequality that we see in Latin America. So this is something that different, both non-governmental, but also official international organizations, such as the Office of the High Commissioner, have expressed in the past year and a half. And also some particular institutions that follow and monitor what's been happening, again, in terms of the restrictions of rights and sort of the how the pandemic has affected the civic space that we all share. Now, in the specific case of Chile, not just because I'm a national and I have, of course, a particular interest in how things are happening in my home country, but I think it's the way, if we think of legal responses in, again, the context of a comparative law conference, in a country that was undergoing a significant, very prominent social, political, I would say also economic crisis, but certainly constitutional crisis that erupted in October of 2019, then the pandemic hit in March of 2020. And interestingly, the very first reaction that the administration adopted, the very first reaction that they took was to declare a state of exception. It would be interesting to hear from participants in this conference and on this panel. It seems to me that the state of exception, which lasted for over 18 months, only now at the end of September, the government decided not to request Congress for yet another extension. It is my impression, but I may be wrong, that this has been the longest state of exception that we've seen in the world in the past during this pandemic. Why is this significant? On the one hand, because of course of what any state of exception, the consequences are the very strong restrictions of fundamental rights. And this is connected to the state of exception that the Piñera administration, the current center-left, right government that is in Chile, had decreed when the social protest of October of 2019 erupted. So there was a sort of continuity in the sense that the first state of exception was a direct response to a problem of public order, right, of social unrest, massive protest, violence on the streets, and the government reacted by imposing this state of exception. It lasted for a few weeks, but then there were very strong concerns of human rights violations being committed by both the police and armed forces. So when the pandemic hit, and the first response was, I would say the first response was a decree of health emergency. But then when the WHO formally declares that this is in fact a pandemic, the government responds by imposing yet another state of exception. And so one strand of I'm not going to get into details. I've written about this in different blog posts and the administrative law review piece that Fernanda was referring to. So one strand is how that state of exception, basically by concentrating power in the executive, has been so fundamental to understand the overall legal response in this country, right? How Chile has reacted to the pandemic by first concentrating an immense amount of power in the hands of the executive. At the same time, and I'll come back to this in a second, at the same time, Chile, as many other Latin American countries, being a nation with a hybrid presidential system. So in normal times, you would have an executive with significant powers. These powers have been enhanced by the state of exception, and Congress, in my view, has been significantly lazy in checking power, in holding the executive, in check. And only, I would say, in the past months, when the situation, the health situation was much better, as a big footnote, we should say that Chile is among the countries with the best record in the vaccination rollout process, much better than many developed countries. And so that has been also a very interesting combination of strong powers, significant restriction of civil liberties, and at the same time, a very notable response when it comes to vaccination, the role of vaccination. So Congress only now has been a bit more strict, a bit more stringent in terms of checking power at the hands of the executive. And then the courts. So we have the executive, to which I'll come back in a second, Congress in its sort of renouncing its duty to check the executive's power, and then the courts pretty much the same. The courts, until March of this year, so for a good year, their attitude was one of strong deference towards the executive, basically saying that because there was a state of exception, so again, this makes the state of exception so relevant, the court would say, well, we cannot really we cannot assess the validity and the constitutionality of many of the measures that the executive has adopted. And it was not until March of this year, in cases that were not, I would say, the most dramatic cases in terms of people, in challenging some of the measures, but people saying, we religious, congregations or religious folks going to the courts and saying, we would like to get together, but the government is not allowing religious gatherings. And it was only then that the Supreme Court of Chile started opening, some questions and saying, we're not sure that the measures that the executive is adopting are, necessary and, more importantly, proportional to the aim that is at hand here. And the second case that the courts started realizing that there were significant problems was some of these very strict measures, for example, lockdowns, quarantines, a curfew that lasted 15 months. And what was very interesting is that the courts only in the past months started saying, if someone violates the curfew, and that's a crime, it's an offense, it's a criminal offense. And so people were being prosecuted. For example, someone who was walking around the streets by herself at night, say at midnight, there's no one in the streets. So from a public health perspective, that person was not posing any significant risk, or a really, really minor risk. There was no one in the streets, there was a curfew, and say the person couldn't sleep, went out for a walk, wearing a mask. And yet, from a criminal law perspective, she was committing a crime. So only recently, I would say the past 6 months or so, the Supreme Court started declaring that those prosecutions could not stand, that there were no significant harms, that there was no risk to public health, and so the public prosecutor could not continue prosecuting people when there were no significant and tangible harms. So those are really very discrete instances in which the courts have reacted positively. The executive management of the crisis, I could talk a lot about this. I'm just going to say how slow it has been, but particularly in 2020, it was in terms of providing assistance, benefits, and that prompted a fascinating constitutional discussion. Congress, again, in a hyper-presidential system, Congress stepped up and started passing constitutional amendments to allow individuals to withdraw part of their pension funds in order to address some of the economic problems that people were facing, very significant problems. Why is this interesting? And this is going to be my last point, because I want to leave enough time, some time for Q&A, that all of this was happening against the background of a constituent process that is now undergoing. And so every discussion, and particularly this discussion on the potential withdrawal of pension funds, took a constitutional form and was significant in influencing the outcome and the development of the constituent process. So some of the discussions, and part of the most important and pressing discussions that were taking place in Congress became constitutional discussions in nature. And those discussions, which had to do with the protection of social rights, benefits, the role of the state, of a government in a pandemic, but more largely how a government, how a state that was structured in the Constitution of 1980, the Pinochet Constitution, has been finally buried by this constituent process, in which the terms of the discussion, the terms of the constitutional discussion, are dramatically changing. We're now going to see next year in 2022 a constitution that, in my view, and many other constitutional scholars, see that it will have a very different outlook. We will see a constitution that protects social rights, and of course the significant challenge will be how the future Congress will be able to implement the promises that these new constitutional texts will establish. So all of this to say how this constitutional crisis, of course, economic, social, and political crisis, was happening during the pandemic, and how the extreme concentration of power at the hands of the executive sort of prompted a more pronounced constitutional discussion that we're now seeing. And it just reminds me of an editorial that we read in April of 2020, right at the very beginning of the pandemic, in the Financial Times, where the Financial Times, which is by no means sort of a leftist, Marxist, social rights friendly newspaper, would say, it might be time to rethink some of our, say, tax structures, some of the ways in which we have organized our social structures. And this is exactly what is happening now in Chile. And the reason why it's happening is because we have provided ourselves with the political and legal space to do this, which is to draft a new constitutional text. I'll stop here, and I'm happy to discuss any further points in the Q&A. Thank you.
Thank you so much for all of those fascinating presentations. And while I give the audience time to pose their questions in the chat or raise your hand, I do have one question just to get us going. And it really goes more to the political and legal dimension of the pandemic, and a common thread that has emerged in a couple of the presentations, and that is this strengthening of the executive branch that really seems to be, it's always been like that in China, something that happened at the outset in Professor Contese's narrative in Chile, And in Italy, the fact that the Constitutional Court weighed down and came down in favor of centralized powers over health, and also that you have a very technocratic government now, which enjoys broad support, but is certainly a technocratic kind of, I would say, since it's Monti, fairly concentrated power at the center. And so, I would, the question really goes to the populist side of this this debate, because I see a lot of the social policy, the social policy part coming through, and the increasing support for social policy in both Chile and in the Italian case. And so we see that, and in Draghi's application for, and I assume granting of money from the recovery fund, will allow for that to flourish, and is a manifestation of the fact that the EU has become much more flexible on the social policy front. So I see that, and I don't see a lot of no-vaxxer anti-expert pushback, which is what we've come to expect, I think, from some of the current developments in this political space and in the reaction to COVID. So I wanted to see if you have thoughts about why it is that there isn't a diffuse anti-expert, anti-vaccine response within Chile, Italy, and other places too. So first maybe Fernanda, and then Jorge.
So briefly, by the way, our estimate colleague Ugo Mattei has become an anti-vax and an anti-Green Pass, and is protesting in the streets and squares of Turin, together with the right-wing populists. And he says always that the left-wing populists need to be there too. But apart from that, your point is well taken. I do think the legal story is an important one. The fact that Marta Cartabia is at the Ministry of Justice, the legal elites, judges, have validated the Green Pass. There hasn't been like, we don't have a derecho de amparo as they would have in Latin America, but there haven't been direct challenges to the Constitutional Court for taking away civil liberties over this issue. I know the medical profession at a certain point tried to push back because they are required, they're the only profession that are required to have the Green Pass, to be vaccinated, sorry. But I do think the legal discourse has been very strong in being upholding the rule of law, not going the Polish way, not confronting directly the rule of law crisis, the rule of law issue. The judiciary has been also very much influential, but also, last thing, the unions have been very in favor of with some exception, very few exceptions, very much in favor of the Green Pass because of the economic recovery. Maybe it's not a big answer, but I'll pass to Jorge.
Thanks, Fernanda. Very briefly, what I would say is, first, there's also a Green Pass, it's called Mobility Pass in Chile. And I think this is connected to two things. One, the very important role that the president of the Chilean Medical Association has played. She was named one of Time's 100 leaders in 2021, and she played a key role in sort of confronting the administration. There was a lack of trust, which is how I articulated my argument in the regulatory review last year, that the main problem back then in April, May, June of 2020 was that the public sort of mistrusted the government coming from the social crisis of 2019, taking this constitutional shape. And then this particular person, she was not just personally, but professionally someone who the people trusted. And so the fact that she became, a key political figure in the conversation about the pandemic, but also about civil liberties, and she was the one who was very strongly saying it is critical that people get their vaccines, right? Vaccination is key to confront this. So, I think it was not something that was planned to happen like this, but her being such a trustworthy figure, political figure, and then Chile having this notable response for the vaccine with the vaccination rollout process, it sort of created this good conjunction of positive elements that made relevant that those who are, the anti-vaccines are really in the minority. And finally, I would say, Francesca, there have been some recent decisions by the courts in which the courts are using a very strong language again against anti-vaccines, saying this is pure and brutal ignorance. And so we've seen now a very strong position sort of aligned with both the administrations of the government, but also these, experts that have become the trustworthy voices during the crisis.
Thank you. That's very interesting. And I don't know if maybe Professor Patz has any reflections on anti-expertise, anti-vaccine sentiment, other places, for instance, where many of us are sitting, because it is a very interesting contrast to how these jurisdictions are dealing with the problem.
Yeah, we're seeing a repeat of individual rights versus public health. And so there's always this conflict when the health science may point to something that is important for the masses to do. And people, will thumb their nose at it and say, well, I want to do what I want to do. But it's just like when the smoking, people could smoke cigarettes, no problem. They can choose to harm themselves. And we didn't have any progress until the secondhand smoke findings came, that when you choose what you choose to do for yourself harms someone else, that's when we had the smoking ban. So it's the same public health story all over again. And I want to ask the question, how is it that a governor in the US can ban, a vaccine mandate or mask mandates when, how is that possible in our own system? It's crazy. But I get very frustrated as a public health scientist when, we're trying to have science drive this, and yet people don't recognize their personal freedom puts other people at risk.
Thanks very much for that. Now, I want to turn maybe more to the global scene and ask a question about the prospect for transnational and global cooperation on all these various issues, and which needs to involve, obviously, China. And so where is that going to be possible? So I thought maybe Jacques or Pataday could offer some reflections on that, because obviously China is an incredibly important player. We can't do it without it. And yet there is so much animosity out there right now, it seems, that it's become more politically difficult. So
do you want me to answer first? Or?
Go ahead.
Yeah, I think there's a lot of mutual animosity, and the hole was dug, I think, during the back and forth between the Trump administration and the Chinese leadership. It got, downright outlandish in terms of some of the charges from the Chinese side, and downright outlandish and more than a little racist in terms of some of the charges from the US side. I think that can be somewhat gotten past, but the underlying poor state of US-China relations, I think, impedes this. And I think we are at a moment where China has shown increasing dissatisfaction with the existing international order. And I don't think it's revolutionary, but I think it wants to have more of an influence in the content, and certainly wants to be given the kind of respect that comes with its position. And of course, we've now got a particularly fraught situation with the WHO inquiries, in which China has not cooperated, and where the WHO, after facing initial criticism for being too deferential, has now, I think, come out quite strongly about the need for greater access. So I think there's a bit of an impasse there. And I would add, from things that aren't so much the law part of this, but some of the international relations of it, that both China and the US came off looking pretty bad in terms of international senses of competence of responding at home and degree of international cooperation in a variety of ways. And one of the hopeful points of cooperation here is the recognition that it takes more than just the China and the US, it takes everybody. And some of the great success stories are smaller countries that took rather different responses. And maybe that will create a little bit of pressure, but the politics of it are just, I think, really bad at the moment.
I mean, there is a lot of cooperation that's going on right now, but I think vaccine diplomacy, China has been exporting its vaccines and has been saying about waiving its intellectual property. And so I think there's pressure on the United States with that vaccine diplomacy to do something on its side. I mean, we've been expanding our amount of vaccines that we're exporting and things like that. So I think there is an opportunity. This is my being an optimist, that maybe because of that and the push that's coming at the WTO with the other members, the developing countries, I just read that Ngozi is right now in India. Now, the Indian-Chinese relationship is one that's not talked about very much, but that's very fraught as well. And that affects things. The US has been trying to bring India into the fold and is working at that. So I think there is an opportunity to maybe that rivalry can cause something positive to come out of it, in terms of this, the issue of patent waivers and compulsory licensing. But I'm being cautiously optimistic about that.
Thank you for that. And I see we have one question from the audience. We have 3 minutes remaining, but I think we have time to take it. If you could just be aware of the 3 minutes. Thank you.
Okay, thank you. My question refers to another aspect, it's more the aspect of Professor Paz, Jonathan Paz, what we do about environment. He referred to all that animal conservation problems, environmental problems. The virus is to be found in animals and then passed to the humans. How many viruses before this pandemic passed through animals to humans? Has someone seen all that historically, the perspective, and what causes all these passages from animals to humans? It's only this destruction of habitats. And I think he's right that it's a cause and effect question. It's not only what we do for the pandemic or against the pandemic, but all we can do in the future to not have a second pandemic by a second virus by coming to the cause and effect, breaking the cause that comes to the effect, protecting the environment in a way that we will not have more viruses. And second thing, we have a constitutional aspect, right to body. I will not do this vaccine for some reasons. I don't have to talk about them, religious or moral or I don't know what. I don't take medicines. They have parts of animals. I was injured. The doctor said me, you need 6 months to see your leg in a good condition, or you take the medicine. I buy it, I see it had part from animals. I drop it down. In 3 days, I was good. My leg had nothing. It was completely cleared from my lung. So someone has reasons, someone has not. What we do with right to profession, with right to speech, we have in Greece, I come from Greece and live in Germany, many doctors, star doctors, they talk against vaccines from a medicinal point of view.
I apologize for interrupting, but we have so many issues there. So,
yes.
so perhaps, Professor, thank you very much for the questions. And perhaps Professor Paz can address maybe the biodiversity part of it, or
yeah. I mean, thank you for asking that question. That's a huge question. Of course, what we really want to do, we want to address every causal link in the causal pathway of a disease that emerges. And we don't look far enough. We look what's in front of us at the proximal risk factors, and we want to detect the first case, but we want to go upstream and understand what's driving that. So here, conservation, wildlife management, understanding wildlife diseases. We've had many transfers from animals into humans: measles, tuberculosis, HIV/AIDS. Those are three big examples. So it's an underappreciated and under-researched and underfunded area to look at these environmental determinants to some of our biggest problems. And that's where I think we can have very wise investment if we look further upstream and consider those environmental factors. Thank you for that.
Well, I'm afraid that we don't have time to consider the multiple issues that have been put on the table here, but I'm very glad that we're able to take a tour of all of them. I thank the speakers for all their fascinating insights and discussion. Thank the audience for your participation. And so all that's left to do here is to really give a big virtual round of applause for the panel and the speakers. Thank you very much. Thank you. Thanks.